Welcome to a podcast from the 43rd Annual Conference of the National Center for the Study of Collective Bargaining in Higher Education and the Professions at Hunter College. The conference took place on April 3rd, 4th, and 5th of 2016 at the CUNY Graduate Center in New York City.
Thank you all for being here this afternoon. My name is Peter Schmidt. I'm a senior writer at the Chronicle of Higher Education, where my beats include academic freedom and academic labor. I'm honored to be your moderator here today. Our panel discussion is titled Title IX, Academic Freedom and Due Process. One does not need to read the Chronicle much these days to encounter some new story about the tensions that result when concerns for academic freedom and due process bump up against Title IX of the Education Amendments of 1972 and its requirements that federally funded education institutions prevent discrimination on the basis of sex, or deal with discrimination on the basis of sex and avoid it. The U.S. Department of Education's Office for Civil Rights has more than 260 investigations of colleges, according to a database that the Chronicle maintains on these issues. As it has pushed colleges to deal with sexual harassment and sexual assault, some colleges and leaders in higher education have been pushing back, arguing that some efforts to enforce Title IX have gone too far. Among those sounding such alarms, the American Association of University Professors last month issued a draft report arguing that the Education Department and many colleges' administrators are fighting sexual harassment and assault on campus in ways that trample the rights of faculty members and students. As examples of such perceived overreach, the AAUP cited 3 cases that we've reported heavily in recent years. One's the case of Patricia Adler, a tenured sociology professor whom the University of Colorado at Boulder investigated in 2013 over a classroom skit on prostitution. Also is Laura Kipnis, a professor of film at Northwestern University, who was investigated last year after students accused her of violating Title IX by writing a Chronicle essay denouncing sexual paranoia on campus. And finally, there's the case of Teresa Buchanan, a tenured associate professor of curriculum and instruction who lost her job at Louisiana State University at Baton Rouge last year after being accused of subjecting students to obscene language and sexually explicit jokes. With that introduction of the subject at hand, I'd like to tell you more about the panelists assembled here today to discuss such developments and their meaning. Seated from to my immediate left, Risa Lieberwitz is a professor of labor and employment law at Cornell University School of Industrial and Labor Relations. She is also general counsel for the American Association of University Professors, and in that capacity advises the organization and its members on many of the issues we'll be discussing today. To her left, Rana Jaleel is an assistant professor in gender, sexuality, and women's studies and faculty advisor for the Sexuality Studies minor at the University of California at Davis. She also serves on the AAUP's Committee for Women in the Profession, also known as Committee W. In her scholarly work, she uses an interdisciplinary methodology to analyze the relationships between law, legal processes, and social justice movements. Finally, to my far left, Suzanne Goldberg is from Columbia University, where she is a clinical professor of law and Columbia's executive vice president for University Life, a nationally recognized expert in sexuality and gender law. She also serves as director of Columbia Law School's Center for Gender and Sexuality Law and its Sexuality and Gender Law Clinic. My plan here today is to give each of my panelists about 15 minutes to speak and then leave a half hour for questions. To keep things moving along, I'll be signaling them when their time is nearly up. And I'd like to ask the audience, at least initially, to focus on asking questions. We'll leave some time for a more open discussion towards the end. On that note, I'd like to turn to Risa.
Great, thank you, Peter, and thanks for being the moderator. So I thought it would be useful if I started out just briefly explaining the process by which the AAUP went about deciding to draft a report on Title IX and how it's been applied, and who was on the subcommittee. So Rana and I are both here as members of the subcommittee, which was a subcommittee that drew from the Committee on Academic Freedom and Tenure and the Committee on Women in the Academic Profession at the AAUP. We had 5 members who were actively engaged in researching and writing the report, in addition to Rana and me, Tina Kelleher from Towson University, Joan Scott from the Institute for Advanced Study, and Donna Young from the Albany Law School were members of this subcommittee, and we just worked very well together. I have to say, it was a real pleasure to work with them. And we produced a very extensive report. The reason that we embarked on this endeavor was because at AAUP we were noticing through some of the reporting that Peter alluded to and other issues that were coming before us, that there were patterns that were emerging of application of Title IX in ways that were disturbing with regard to the impact on academic freedom, due process, and faculty governance. And we wanted to do an extensive study that looked at the history of Title IX as well as its current application. And the report that we produce, it's an extensive 55-page report, but we do have a shorter executive summary, so I encourage you to read both of them. The report we produce is called The History, Uses, and Abuses of Title IX. It came out on March 24th, so just a little while ago. If you go to the AAUP website, aaup.org, just type in Title IX in the search box, it will be the first thing that appears. And we do encourage you to not only read it, but if you have comments, we've posted it with a public comment period, because we'd like to hear from whoever is interested in providing comments, clarifications, information. We do encourage you to do that. And so, right out of the box, I want to say what should be obvious, which is that we take issues of sexual harassment, of sexual assault, we take these very seriously. AAUP has always done that, and AAUP has long time taken the position that there is and should be a coexistence and a consistency between taking seriously issues of sexual harassment, sexual assault, sexual misconduct. We should treat those, deal with those, remedy them, and prevent them. At the same time that we should recognize the importance of academic freedom and due process and faculty governance. And academic freedom, due process, and faculty governance should not be sacrificed because of a fear of appearing that we are not taking sexual harassment seriously. We take them both seriously, they both coexist, and that's long been AAUP's position. So what we see that we discuss in the report, it's extensive, and I'll highlight some things, and then Rana will take over and highlight others, is first, we looked at OCR, Office for Civil Rights of the Department of Education, as Peter said, enforces Title IX, and our concern in looking at OCR recent interpretation of Title IX, particularly since 2011 with its so-called Dear Colleague letter, is a tendency for OCR to conflate conduct and speech, as opposed to having a very clear distinction between conduct which should be regulated, sexual assault, sexual harassment, and that conduct within it could include some unprotected speech. Clearly, we are not saying that all speech is protected speech. As part of proving sexual harassment, particularly hostile environment harassment, there may be unprotected speech. However, what we are seeing from OCR is a tendency to overly broadly define hostile environment in particular in a way that is intruding or threatening to intrude on academic freedom of faculty in the classroom, in their research, as well as in their extramural speech, generally their public speech outside of the classroom and research venues. We're also seeing definitions that are overly broad with regard to hostile environment for students as well, and I'll talk about those more later, but primarily I'm talking about faculty here. Now, this tendency to overly broadly define hostile environment and to undervalue academic freedom is something that is very disturbing for a university in particular, because in a university, we all know that the principles of academic freedom call on us to fulfill our mission through active debate, through dispute, through having controversial issues discussed freely in various venues. And so the threat to overly broadly defining hostile environment can intrude on some of the basic principles that the university stands on. Now, I want to point out that OCR had earlier in their guidances under Title IX had an emphasis on both academic freedom and free speech, particularly in 2001 and 2003. Guidance from OCR did take those seriously in both public and private universities. But particularly since the 2011 Dear Colleague letter, as I said, there seems to be a conflation of conduct and speech in discussing Title IX definitions without putting in the important caveat that speech must be protected under academic freedom and that due process should be applied strongly. The broadening of that definition of hostile environment, in particular by OCR, emphasizes the subjective nature of individuals' responses to either unwelcome conduct or verbal speech of some kind, could be written as well, but speech. And that emphasis on the subjective then de-emphasizes, or to some extent may ignore, the objective factors that go into defining hostile environment. And with that emphasis on the subjective, this can then lead to a rather undifferentiated definition of what a hostile environment is and what speech is unprotected. Now, in responding to OCR, I want to move to what university administrations have done, because we do have a critique of OCR, and again, now I'm talking about the academic freedom aspect of it. But the university administrations, I want to emphasize, should take responsibility to fulfill their own independent obligations to protect academic freedom and due process and faculty governance. And so what we're seeing, again, in terms of patterns discussed in the report, is that in responding to OCR and the increased scrutiny by OCR, the increase in investigations, of compliance investigations carried out by OCR, that universities are responding in kind of a risk management approach, a fear of being highly scrutinized, and that this leads to universities themselves adopting approaches to defining hostile environment that's also overly broad in regard to judging and evaluating what faculty do in the classroom and outside the classroom. And so Peter alluded to some of the well-publicized cases, like the case of Professor Patty Adler at University of Colorado in Boulder, who was teaching a course on deviance, used some role-playing, which she'd been using for many years very successfully in her class. It's a very popular class. But because of complaints about some role-playing that addressed issues of gender and sexuality, that the administration of the university took action against her, and there was a whole series of very fast actions without taking seriously faculty governance to try to get her retired, tell her she couldn't teach the course anymore, then bring her back because there was a pushback from faculty through governance, and then finally she retired. Teresa Buchanan, as Peter noted at LSU, she went from being on the road to a successful promotion to full professor to being fired because of allegations of hostile environment, which appeared to be nothing more than that she used some language that might have been profane and that somebody didn't like that. We have other examples in the report as well in terms of research, but those are ones that are well reported. And of course, the Laura Kipnis case from Northwestern University is an example of extramural speech being invaded through overly broad allegations and definitions of hostile environment, where her article in the Chronicle of Higher Education was alleged through complaint to create a hostile environment. And even though she was so-called exonerated, she had to go through an intense sort of interrogation of an investigation that should never have taken place. Clearly, the article that she wrote did not create a hostile environment. And so, what are the problems with this? Well, obviously, it's a problem if individuals are being faced with either threatened investigations, actual investigations, threatened punitive measures, actual punitive measures that harms those individuals. But it also creates the chilling effect that can be so harmful in a much broader way, where faculty hearing about these kinds of reports fear that they will be the next target of an investigation or a complaint. And so the kinds of stories that we won't hear about oftentimes are the self-censorship stories, the issues of, I'm not going to go there, I can't afford to be targeted. And this fits into reports that we describe in our broader AAUP report about some faculty saying they're avoiding certain subjects in class, for example, in teaching rape law. Some people are avoiding teaching it because they don't want to discuss difficult issues of censorship, of consent, of cross-examination, because they may be charged with creating a hostile environment. This also fits into a broader context that AAUP has addressed before, very importantly, of so-called trigger warnings, that we have a broader culture being created on campuses where demands by students, which are heard by some administrations with in a positive way, then translate into so-called trigger warnings to warn students that there may be controversial or disturbing information in the classroom. And that might be trigger warnings in syllabi or announced in class. And even encouraging faculty to do this interferes with academic freedom and the ability to have difficult, surprising conversations in class. Civility codes are another aspect that shows this broader context of censorship that is related sometimes directly and sometimes indirectly to the Title IX issues. So let me move briefly to talking about one other aspect that we address in the report, and that deals with the issue of due process that I've alluded to. The 2011 Dear Colleague letter from OCR mandates the use of a preponderance of evidence standard in investigating and hearings under Title IX on college campuses. This is an interpretation by OCR, but it is put in the letter as a requirement, even though later, and quite recently, OCR has acknowledged that the Dear Colleague letters and their guidances do not have the force of law. Universities are taking this as if it is a legal requirement. And so the preponderance of the evidence standard, which is oftentimes defined as more likely than not, is a lower level of due process than a clear and convincing evidence standard, which is defined as highly probable or reasonably certain. So it requires more evidence in order to fulfill and prove a charge. Universities have generally responded to OCR by saying, well, yeah, we're just going to lower the standard of proof. And they do this even though it's not, as I said, not actually force of law from OCR. The fear that OCR will then take compliance measures seems to be enough for universities to respond by simply lowering the standard of proof. OCR is saying you cannot make that choice in the university to have a higher standard of proof. Now, AAUP has long time, and we continue in this report, taken the position that due process is very important when faculty and students are facing potentially severe impacts on their future. Here now focusing on faculty, you could have somebody who's fired, who has other punitive measures taken. This may affect their lives. And so the importance of that kind of decision requires a high enough level of due process that we can be reasonably certain that we're doing the right thing, that we are creating a system that is fair and that has adequate levels of due process. There's much more to talk about with this. Rana is going to talk about other aspects of the report. I would just add one tag, which is that our recommendations in the report, we have quite a few recommendations at the end, both to OCR and to administrations, as well as to faculty, include the importance of defining clearly hostile environment and sexual harassment in a way that also defines clearly protected academic freedom. And we also call on OCR and administrations to have adequate due process protections.
Okay, thank you, Risa. And I also wanted to just thank Suzanne for being here, because I'm new faculty at Davis, and before that I was a Center for Reproductive Rights Fellow at Columbia Law, where Suzanne was, and her work's always been it's been a real pleasure to just watch you work, basically. So I'm really happy to be on a panel with you. And Risa knows how much I admire her, so I don't really need to say anything there. So what I'm going to talk about now is think about Title IX implementation in the context of the corporate university, and then also address what the AAUP policy is and has been, and what our recommendations are to try and combat try to alleviate some of the concerns that Risa's laid out. And just to give you a quick cheat sheet for the end, our recommendations are always going to be to try and protect academic freedom and do it through robust shared governance. So I'll talk about why that's important as we go through this. So as Risa mentioned, recent Title IX initiatives have narrowed the popular meaning of sex discrimination to focus on sexual speech and sexual violence, and these two things have often been conflated. But the other thing that I wanted to note just from the start is that Title IX is actually, when it prohibits sex discrimination on campuses, it concerns more than just sexual violence or sexual speech. It also includes issues of unequal pay and access and educational opportunities and representations throughout the university system. So one of the things that's happened with the way Title IX has been implemented so far is there's been also a narrowing of popular meaning of Title IX to basically focus on the sexual. And so that, so to us, that's also a problem. And to me, this raises two very big questions that are going to kind of structure the rest of the talk. And the first is, what vision of justice, educational access, and public accountability should the enforcement of Title IX seek to facilitate? And then, relatedly, how can we achieve that given the realities of how universities work in the context of where there have been increasing threats to shared governance and academic freedom that the AAUP documents in many cases beyond Title IX. So, again, here context really matters, and it's important when gender justice is something that we're seeking to achieve. We look at we look at the material realities on the ground and think about it that way. And that's for those of you who follow feminist or gender studies, that's always been an issue with feminism, and that's one of the reasons that this report means a whole lot to me, because it's an opportunity to kind of broaden the discussion a little bit. So to start, the first thing I want to talk about is how Title IX as an instrument to fight sex discrimination on campus must be evaluated in light of the increasing corporatization of the university. And that phrase, as I'm using it, refers to the organizational model of university managing governance that is entrepreneurial at its core. So the university is also involved in real estate deals. The university functions as much as a business with a brand as it does as an educational institute. And this is in part a result of reductions in state and federal support for higher education. This isn't I'm not necessarily looking to blame. I'm trying to describe a reality. But the new model also reflects some vast cultural changes in thinking about the value and function of higher education. And this one's more oriented towards vocational training than to humanistic learning. So this is also part and parcel of the cuts against programs in the humanities and the need to produce students who can get jobs, even though what kind of jobs they can get or what criteria are necessary for those jobs is not necessarily something that's very clear. And it relies on a logic, for example, that if we encourage biology classes, any student who takes a biology class is going to get a science job, and it's just simply not true. You can ask my brother that. He's now an accountant, but he was a biology major. So this entrepreneurial model privileges administrative managerial methods and interest. It evaluates and eliminates departments and disciplines according to borrowed business metrics of economic efficiency. And it also promotes a commercial model of universities in which student satisfaction as educational consumers becomes paramount. And that's a really tricky thing to kind of navigate, because I think faculty all know you want your students to get something out of your course, you want them to be happy, but there are also limits to what you can do. You can't really cater to them if you're interested in educating them. You especially can't do that if you're gender studies faculty or you teach queer studies like I do, where I talk about sexual violence and race all the time. And so I have to stand up now at the top of every class and say, just consider the syllabus a trigger warning, because there is no way I can adequately prepare you for the shock of every week. Because if we're looking at the history of queer studies through the lens of race, it's a story of threat and violence and resilience, but it's also not a very civil story. There's as much proud to be gay as not gay as unhappy, but gay as in fuck you, as queer as in fuck you. So this is just the content of the course that you kind of can't escape it. So this is why this educational consumer kind of model, it can be really, really problematic in the context of speech in these courses. So in this context, problems of definition with Title IX end up being compounded by administrative and governance structures in the entrepreneurial university itself. So these are ones that promote, and this goes back to the question of what kind of Title IX do we want, or what kind of vision of justice do we want? Because you get, on the one hand, universities promoting Title IX, while on the other hand, they adopt priorities that don't favor programs in areas of studies that exist to analyze how sex, gender, power, and advantage operate. For example, in universities, and this is really true at a heavy science school like where I am, there's a real importance placed on getting external funding, which in turn ends up kind of devaluing programs such as gender, feminist, and sexuality studies, which are unlikely to have the same kind of research grant opportunities as maybe some of the harder science departments would have. And the current focus, again, on measuring higher education in terms of path to employment also lowers the perceived value of such programs. So gender studies programs and allied disciplines such as Africana studies, Latino studies, and other locations for gender and sexuality inquiry across the humanities and social sciences are also part of this kind of this moment of setback and cut and austerity. So one recent example that I'll give you is the drastic 40% budget cut for ethics studies at San Francisco State University that was part of the structural undercutting of ethnic studies across the Cal State University system. So they pushed back on that, but the threat is still there, and it's only, as far as I understand, they've only kind of bought themselves another year. But I should have followed up on that more, but I've been traveling. But the point is, these are the programs that are on the cutting block constantly. And at Berkeley in 2015, the administration proposed repositioning the Center for Race and Gender, effectively decreasing its institutional support. And some of the rationales for this where they charge the center with contributing to divisiveness on campus by stressing collective over individual experience. So there's something really at stake in how sexuality and gender are functioning at the university, that these Title IX issues, you can't blame Title IX for everything, but you have to be really, I think you have to be really careful about how you're going to deal with a really complex, how you're going to implement these Title IX on a university landscape that's this complex and this fraught already. One of the ways that Janet Halley and some professors at Harvard have criticized the Title IX infrastructure is that they've established a single purpose office that just does Title IX complaints there. So one of the arguments is that when you have just single purpose infrastructure, you automatically lose other civil rights complaints that should also be maybe looked at a little more holistically. So race, complaints around race or disability are kind of falling out of the analytic. And given our nation's history of how race and sexuality and gender violence are deeply intertwined, you're not going to necessarily get a full picture of gender violence if you kind of resolutely and narrowly focus on sexual violence just through a gendered lens. So that's something that's important. Additionally, administrators, corporate service, and client relationship to students can obscure the question of how to deal with criminal behavior on campus. And this is the example that really blew my mind and really got me invested in this report. And it's that the University of Colorado at Boulder kind of tried to have everything both ways. So they recently settled a lawsuit for $15,000 from a former student who said the university violated Title IX when it suspended him for non-consensual sexual intercourse. So the university punishes the guy and then pays him $15,000 in damages, which, while this satisfies the law and it satisfied the accuser by finding the accused responsible, this is really bureaucratic and legal logic at work that's not in the service of addressing the question of whether sex-based inequality is actually being remedied. So we have to kind of go a little deeper there. And so those are some of the questions with just the corporate context that I just wanted to lay out. Now I'm just going to switch into AAUP policy, because clearly there's no silver bullet for this. Clearly, Title IX is, Title IX is one of the best, or could potentially be one of the best legal means we have of addressing this kind of stuff on campus. So it's not to necessarily throw it all out, but the AAUP policies are to try and provide kind of a better groundwork and a framework for it to operate in. So the one thing to be really clear with from the outset is that the AAUP has never understood there to be a necessary contradiction between effectively addressing problems of sexual harassment, from assault and inappropriate conduct to unprotected speech, and fully protecting academic freedom. AAUP policies have consistently condemned sexual harassment while emphasizing the need for universities through shared governance to adopt clear, fair procedures and policies pertaining to sex harassment. And they've also emphasized that university policy and procedures should respect academic freedom and due process rights, and should not seek only to respond appropriately to sexual harassment, but also to prevent it. So there's a preventive element in here that we're also really interested in. AAUP statements and reports emphasize that shared governance is essential to creating and implementing programs, policies, and procedures to address these concerns. So as the 2012 statement on campus sexual assault states, quote, all members of the campus community, faculty members, administrators, staff members, and students share responsibility for addressing the problem of campus sexual assault and should be represented in the policy development process. And our recommendation is that this should occur at all stages, because faculty are on the front lines of these debates. They're doing the research, they're hearing about sexual violence on campus when they're on campus talking to students. There's a direct line of relationship with the students, and that's something that necessitates their inclusion in the process. This 2012 statement also discusses, quote, the special role and responsibility of faculty members, a group often overlooked in campus sexual assault prevention and training programs. So there has to be much more engagement on that front. The 2014 report on sexual harassment also proposes procedures for handling sexual harassment complaints against faculty, including a faculty review committee to hold hearings, determine the merits of the complaint, and to make recommendations for any sanctions that must be appropriate. So peer evaluation from people who understand the context of the university that they're in and the context from which these complaints arise is very important. And additionally, this same report distinguishes between sexual harassment and protected speech. That's something Risa's already talked about, so I'm going to just skip over that part. And finally, and she mentioned this as well, the AAUP's Committee on Women in the Academic Profession has endorsed a clear and convincing standard as the best way to ensure that due process rights are protected throughout a process that can be extremely sensitive and very complex. And it is precisely because of that kind of complexity that the 1994 Statement on Due Process in Sexual Harassment Complaints emphasizes that universities should not bow to pressure to sacrifice fair process in handling sexual harassment complaints. The duty of the university is to ensure academic freedom, fair process, and shared governance, and that is especially germane given the context of any attempt to enforce Title IX within an increasingly corporate or entrepreneurial university. And so for this reason, and I'm going to conclude here, a return to an educational mission that is characterized by strong faculty governance is really critical in this situation. And to our minds, that also includes a commitment to interdisciplinary learning, to gender studies, and to allied disciplines, to the disciplines who teach, research, and otherwise deal with social inequality as part of their professional lives, and also part of their personal lives. And this commitment to education is also consistent with the AAUP's 2012 statement on sexual harassment, which recommends educational programming as crucial to any strategy to quote-unquote proactively end sexual violence. So I'm going to stop there and turn it over to Suzanne. Thanks, everyone, for coming out.
Great, thanks so much, and thank you for giving me the opportunity to comment. My plan today is to, first of all, talk about some space of general agreement that we're on these issues of sexual harassment, Title IX, university policy, and then in my role as a law professor to raise some questions and to point out tensions. And I should say, consistent with that that's really how I'm speaking here as a law professor with expertise in sexuality and gender law. I'm not speaking on behalf of Columbia, certainly on behalf of its Title IX policies or anything else, even though I do some work in that domain, but I'm really speaking quite individually. And it's an area that is rich and interesting, and I'm glad to have the opportunity to talk about. So just to speak to areas of commonality first that I think are worth sketching, reiterating really what you've said. I think there's wide agreement, right? No contest really, that Title IX's prohibition against sex discrimination in higher ed and actually in all educational settings reaches sexual harassment, right? It prohibits sexual harassment. And it's also clear that sexual harassment encompasses both quid pro quo, right? You do this with me, or you don't get to be promoted to X rank, or you don't get an A on your paper, or whatever else, and hostile environment, right? And it's also clear that hostile environment claims include not only conduct, right, not only, say, brushing up against somebody physically without their consent or engaging in other unwelcome physical contact, but also include verbal communication. And so that's, right, so there's a Venn diagram, and there's some overlap between the speech, and the question really is what speech is protected and what speech is not protected. It's also clear that the hostile environment claim, when courts look at it, the question is whether the complainant or the plaintiff has experienced the environment subjectively as hostile. In other words, did I experience what happened as a hostile environment because of my sex? And also objectively, would a reasonable observer look at what happened and identify sex discrimination in that? And even though I think you point out that could raise a concern about OCR's letter providing insufficient attention to the objective lens onto a situation coupled with the subjective lens, I think OCR has, and I'm certainly not here to defend OCR, but I think it has said repeatedly that the analysis of a hostile environment claim comes from both an objective and a subjective standpoint. And so then what meets the threshold of sexual harassment? So under Title IX, the threshold, as probably everybody here knows, is that the conduct that's charged must be severe or pervasive. There's some debate, and the report covers this, is it severe or pervasive or severe and pervasive? You know, as a lawyer who thinks about these issues, I think that the difference is important in some ways. I don't want to minimize it or diminish it. Title VII, the language is clear that we look at is conduct severe and pervasive, and there's a question whether under Title IX, severe or pervasive. I mean, in my personal view, if the conduct is severe or it's pervasive, we have a problem, and it's a problem that ought to be addressed, but we can talk about that more. And so then what comes under the sexual harassment category? So let me just share with you what the Equal Employment Opportunity Commission has said with respect to Title VII and sex discrimination. Right, and I know, again, we know this, but just think it's worth pointing out. Harassment is unwelcome conduct based on sex. Harassment becomes unlawful where enduring the offensive conduct becomes a condition of continued employment, that's the quid pro quo, or the conduct is severe or pervasive enough to create a work environment that a reasonable person would find intimidating, hostile, or abusive. Now, there's always going to be concern about, well, what do those words mean, right? That's the nature of the legal process, that we have a lot of legal standards that use terminology, and the case law and the policies around them fill them in. But the hard questions on the line are, what is severe enough? What is pervasive enough? There's a hard question too sometimes, was the conduct really based on sex, right? What is conduct anyway? So under Title VII, the EEOC has said petty slights, annoyance, and isolated incidents, unless extremely serious, will not rise to the level of illegality. To be unlawful, again, the conduct must create a work environment that would be intimidating, hostile, or offensive to reasonable people. And then the EEOC goes on to define offensive conduct, including, that may include, but is not limited to, offensive jokes, slurs, epithets, or name-calling, physical assaults or threats, intimidation, ridicule, or mockery, insults or put-downs, offensive objects or pictures, and interference with work performance. So there's a lot in there that, as I understand the report, you might be concerned about regulating when it comes to a university environment. So but those are, I think, gives us the big picture of the issues. Let me now move on to some of the tensions and the questions. And I think the overarching question I want to raise for discussion or for thought is, who shapes the culture of Title IX enforcement? Right, because we have the Office of Civil Rights of the Department of Education that issues Dear Colleague letters and issues other sorts of policy guidance. But they're hardly the only participant in the conversation, right? There are all of the commentators, legally trained and otherwise, who have strong views about what Title IX should mean in a university context. We have students who have strong views about what Title IX should mean in a university context, which range quite widely from how the university should handle complaints, what kind of adjudication process there should be, to whether universities should pay for 4 years of counseling if a student has experienced a sexual assault on campus. There is, of course, the media as part of the conversation here. And I think, Rana, when you said, well, the focus of Title IX conversation right now is so much on sexual assault, and I think actually to a significantly lesser degree on sexual harassment concerns, and much less on many of the other concerns. And athletics, which had been the primary focus of a lot of Title IX conversation, is really nowhere to be found, at least in a lot of the public debate. So again, the overarching question, who shapes the culture of Title IX enforcement? And on that issue, I think each of us has some responsibility to weigh in, right? Whether it's in our university settings or more broadly through organizations or otherwise. So let me talk about, let me see how many I have here, 5 different issues on which I want to raise some questions or raise food for thought. Right, one is the question of complaints that are filed and chilling effects of complaints. So there's a concern that both of you mentioned and that I've seen elsewhere, that when a complaint is filed, that complaint may not only chill the individual against whom it's filed, but also others on that particular campus and perhaps other faculty members across the country. And that's invariably true, right? And to me, some of the things to think about there are, first of all, when civil litigation is filed, it can have the same effect. And actually, there are Title IX cases, as people here are probably aware, that have been brought that have included professors as defendants that are being processed and being publicized entirely outside of the university domain. So I don't think that the chilling comes entirely, or even maybe for a second reason, in the majority from what universities are actually doing, since the examples that you've cited are pretty few and far between. I'm not diminishing their seriousness, but I think they are not probably, in my view at least, but I have not empirically tested this, what is predominant. I do think there is a significant culture of students filing complaints. And filing complaints in a formal adjudication process, but also filing complaints via social media. and via student media. And that, I think, is, does have a significant effect on how faculty choose to teach. I think it has always had an effect, just coming from the law school background, of how faculty choose to teach or not teach sexual assault. But I think it has always had, it has had and will continue to have, and will have more and more of an effect on how faculty teach a range of issues that touch not only on sexuality and gender law, but also, Rana, as you said, on race, ethnicity, on poverty, on police violence, right? There are many, many issues that where faculty can become the subject of complaint for the way they teach or don't teach that have nothing to do with the institutional apparatus of the university. So I think that's an interesting question to think about. A second question is the question of what is the standard when there is a complaint that goes into the adjudication process? What is the standard by which that complaint should be reviewed? And the predominant standards in civil litigation, is everybody here lawyers? I'm not even sure. How many people are lawyers and not lawyers? Okay, so it's about half and half. So the predominant standard in civil litigation, and civil litigation is just any litigation that's not criminal, right? So the standard that's usually used is what's called the preponderance of the evidence standard, right? Is it more likely than not that the defendant did the things that the plaintiff is accusing the defendant of having done? So if I file a Title VII lawsuit claiming sexual harassment, and I sue a colleague, that lawsuit will be, the evidence that I present of sexual harassment will be evaluated under this preponderance of evidence standard, under this standard more likely than not. That's the standard that is being, that OCR has said, the Office of Civil Rights inside the Department of Education has said should be applied by universities in sexual harassment cases. There's another standard, which is the clear and convincing evidence standard, which is a harder standard to meet, right? Not only do you have to show it's more likely than not, you have to show by clear and convincing evidence that the defendant did these things. Now, that's only the second standard. In the criminal context, as everybody surely knows just from watching TV, if nothing else, right? The standard is beyond a reasonable doubt, and that's the toughest standard. Any of those standards can satisfy due process. Right? Because the question in due process, and this is another aspect of what I teach in a first-year law school course, is what due process was really essentially a question. What process is due under the circumstance? What procedural protections do we need in place to make sure that both sides have a meaningful opportunity to be heard, and in particular that the person being accused of something who might lose something as a result of this process has a meaningful opportunity to be heard? With that being the question, I think to me, there's nothing inherently right or wrong about the preponderance of the evidence standard or the clear and convincing standard. Some of it depends on the institutional culture. What will make more sense may depend on the institutional culture. At the end of the day, though, to me, the key in these matters is the training of the people doing the investigation and adjudication. I think a clear and a preponderance of the evidence standard is perfectly capable of achieving fair results so long as it is administered by people who are well trained. Happy to talk more about that. I see my time is running more quickly than I had anticipated, so let me just mention quickly the three other areas for conversation. What about trigger warnings? I think talking about trigger warnings accepts the frame that a lot of students have asked for. They've asked for trigger warnings. Lots of faculty use, and lots of websites use something else as a frame, a content notice, if they think it's appropriate, right? And so, for example, in a sexuality and gender studies class, the content notice is the syllabus, right? It's not clear that anybody would be benefited by having an additional content notice on top. I don't think that the predominant view of most universities that I have seen is to advise faculty to have these. I do think, though, there's an interesting question, as I've listened to people debate both sides of content notices, is what is going to help students thrive in the classroom, right? What is going to help students engage in the sort of intellectual, uncomfortable debates that we ideally want to be having? That's a very separate question, and I think an important conversation to have that really gets away, that is apart from the should content notices or trigger warnings be mandated. And in fact, I think some of that conversation about the mandating of trigger warnings has functioned as a red herring to take attention away from the significant and hard question of what do we want to be doing in our classrooms? Is it a good thing for students if we list resources related to a range of things, mental health and wellness, in addition to sexual assault prevention and response, and maybe a number of other issues? So there's something to, I think, another question. A fifth question, or fifth or fourth, whatever is on my list now, on the sort of corporatization of the university and thinking about risk management. I don't have a lot to say about that, but I do want to raise an observation that I couldn't have made 2 years ago, but I've become involved in university administration since then. So it's one of the things that has been most striking to me in the transition from being a faculty member to being a faculty member who also does administration is the very sharp divide between student life and academic life. And when I was on I still am on the faculty of Columbia Law School, but when I was just a faculty member, I didn't know that much about what was going on the student life side. I maybe knew more than some of my colleagues because students would come to me and I would want to guide them toward resources. But I think that seeing things through the lens of the corporatization of the university and that is the reason, and risk management is the reason, misses part of what is happening in a lot of universities, which is that student life administrators are really hearing regularly from students who are suffering, right, or experience themselves as suffering. And those students need guidance and help. It's not often faculty who are providing that help. And so I think, again, I want to suggest that it's a more complicated picture than some of this discussion might suggest. And the last quick point is, as a complement to the shared governance idea, it seems to me that it would be quite useful to share a valuing of how best can faculty teach each other about what sexual harassment is and isn't, and do the kind of training of each other. And let me just close maybe on a quick question. How many of you have had sexual harassment training? How many thought it was really good and stuck with you in significant ways? I think that's where, in case people couldn't see, right? I couldn't see if anybody raised their hand, but I didn't see a lot of hands for sure. I think that's a place where all of us could benefit from some serious work. And I would encourage anybody here who's interested in doing that work. I certainly think about it a lot as we think about these questions and raise concerns about disciplinary processes. Let's also think about how really do we shape behavior so that we don't have as many issues as we appear to have of either faculty sexually harassing students or students sexually harassing each other, or anybody in our university communities engaged in sexual harassment or sexual violence toward one another.
Thank you. I'd like to take the liberty of asking a question myself here before I turn it out to the rest of you. As somebody who sometimes feels like I should have a trigger warning before anybody says the term faculty politics, I will be shaking after a day of dealing with it at the Chronicle. I was interested in watching the session earlier, the previous session dealing with mandatory reporting requirements. And I'm wondering how they factor into this mix and whether there's any potential for mischief in terms of faculty members feeling obliged to report on each other, or has that come up at all? Mm-hmm. And just basically address the mandatory reporting issue.
Do you want to address it?
You can go ahead and I'll go after. I
Yeah,
just
then
talked a
you'll
lot.
chime in.
So.
Okay. Well, we do address that in the report, the issue of mandatory reporting, because that does play into the question of academic freedom, as well as issues of faculty relationships with students. So, as Rana said, we were looking in the report at this broader context of what does it mean to look broadly at moving forward with gender equality on campus, and how do we do that in a way that is complex, multi-layered, and that looks at all of the pieces that are important in trying to actually achieve those broader goals. And I think that, as Suzanne was saying, those are areas we all agree on up here. We want to move forward. And so looking at the way that mandatory reporting has been defined on some campuses disturbs us. There are some campus administrations who say, well, we have to have every faculty member be a mandatory reporter, so-called responsible employee, to report any sexual misconduct that they hear about or see. And OCR has clearly not required that. OCR continues. In the last session, the representative from OCR said, we leave it to the universities to define how broadly they want to define mandatory reporters. And again, I think that is a risk management kind of approach, that universities say, well, we really have to do this because we're afraid that OCR will say we're not interpreting Title IX correctly, and it's a lot easier to define everybody broadly rather than to say, well, who should actually be a mandatory reporter? And we recommend that mandatory reporting requirements should be narrower to a great extent because we want students to be able to talk with their faculty members in ways that do not put the faculty member in this kind of automatic box of having to go report on the student, removing choices from students about how they want to handle situations. So a more nuanced approach to that kind of requirement is one that's essential for us to have, to make progress toward gender equality, to allow for open discussions when they are useful in the classroom as well as outside of the classroom, rather than imposing some rule where undoubtedly faculty are going to be afraid to speak to students about issues that are of importance. And this also has a disproportionately negative impact on women faculty, and particularly women faculty in areas of gender and sexuality studies, social work kinds of studies, where the students may feel most comfortable going to those faculty and believing that those faculty have more knowledge of how to deal with those kinds of issues. I think so.
So maybe I'll just add a few thoughts. I actually think it's a complicated issue. And so I'll just raise maybe 3 points. One is from a risk management perspective, there's certainly an argument that, well, we make everybody a mandatory reporter, train everybody, and then everybody, all faculty will be mandatory reporters, and we're all done. I also think, I mean, I'm not a risk management person, but if, from a risk management perspective, you could say, let's make a smaller pool mandatory reporters, and that way we know that that group really will be well trained and will actually do the reporting that we require of them. If we make the full group required mandatory reporters, then what do we do about, the 70% who weren't paying attention during the training and don't really fully absorb what their responsibilities are should a student report? So there's exposure to liability on all sides of the mandatory reporter requirement. I guess I think from two other issues are worth thinking. Hopefully that was clear. I don't know if that was, did I make that clear? Okay. The two other issues I think are worth thinking about is we do, generally speaking, I think, want faculty to be knowledgeable about the resources available for students, both with respect to sexual assault and harassment and the array of other issues. Mental health resources is an example that strongly comes to mind that they may need. And again, because of that student life, academic life divide, I think the faculty often don't have all of that information at the ready. So there's a question and an interesting challenge. How do you make faculty knowledgeable regardless? Because students could come in and have, let's assume, non-mandatory reporter, have a confidential conversation with the faculty member who really has no idea what the resources are or where to send a student. So how do you get that cohort of faculty who might hear this information, how do you educate that group to know where to send students who need help beyond the individual faculty member? I do think also that when we think about the number of faculty members who are likely to hear from students about experiences of sexual harassment, it's an extremely small percentage of any faculty, right? And you can sort of think about it in demographic terms, but you can also think about how many students are, when you look at a faculty I look at my colleagues and I think, how many students are comfortable going to various colleagues about different issues? I think lots of people are comfortable going to faculty about career advice. I think many, many fewer are comfortable going to faculty about anything personal. So then, so it is a small group. But I don't think it's feasible for a university to think in those terms and identify and do training in those terms, which is why it will naturally be a broader brush training. I think the other question that is complicated is, when we think about this from a student perspective, what do we expect students will think when they talk to a faculty member, right? So one of the reasons behind the OCR's, behind the Office of Civil Rights move toward expanding the group of faculty who should be mandatory reporters, I'm sure you went over this in the last panel, was that students were telling an official of the university, right, their professor, who could be more official than that, and expecting that the university was on notice that there was a problem in a dorm, or there was a problem with a particular student, or there was a problem with a particular coach. And the university, nobody else was finding out because the faculty member wasn't sharing it with anybody. Now, there's a lot you could do in between having everybody be mandatory reporters and having nobody be a mandatory reporter. And so the question, again, I think comes back to how do we educate ourselves and our colleagues about these issues? And that, again, is where I just come out over and over, which is whatever the rules are, the real challenge is in the information absorption and making sure that that happens.
Can I just add one more thing? I mean, it seems to me that the last point that Suzanne made fits directly into our discussion about faculty governance. It's not enough to say, oh, well, we're just all responsible for knowing about this. What we need to do is have a system where faculty governance processes, whether that's through faculty senates, faculty standing committees, ad hoc committees of faculty, collective bargaining where you have unionized campuses, that's where faculty function in a way that governs the university in areas that affect them. And there may be discussions about, well, how broad are those areas that affect them, but clearly this is one of those areas that affects them, so that when you talk about education, we're all on board with that. Education, prevention of problems, really dealing in a nuanced way that really helps students, all of those things very positive. And that faculty governance processes are the way to bring faculty in a democratic process to say, how can we best do this so that we're all connected to it, which then leads better to education rather than a more removed process of training. And so the issue of mandatory reporters that I think you're raising, Peter, I want to talk about the difference between that approach, which then says, and if you don't, then this is what will happen if you don't report, as opposed to how do we look broadly at doing the education, at educating ourselves and working out good policies by bringing governance, faculty governance, early in and throughout the process.
And I would just say, if there could be a next report that actually focuses in on how does, assuming, I don't know what percentage of faculty is typically involved in the governance process, but it's pretty small, I think, at a lot of places, under 1 in 10. So thinking about substantively what kind of, writing a report that really talks about, well, how do we educate each other on sexual harassment, or what are some best practices? What are some best practices for having faculty learn about the resources that are available at an institution? That seems to me to be could be a really useful document to have.
Yeah.
You have a question?
Yeah, Aaron Nissenson, AAUP, and so I know two of the panelists very well. But I won't follow up with an AAUP question. I had sort of a broader one, and it goes back to something I asked earlier today, which is that it seems like a lot of the Title IX mechanism is focused on individual correction of individual complaints, rather than creating a culture on a campus that prevents sexual violence and deals with the underlying causes. And it also seems like there is a system that's placed on all campuses regardless of their local conditions. And so, when you have these settlement agreements, a lot of them are modeled on each other, even though you have large rural institutions that have lots of fraternities and very little other activity, versus very small liberal arts institutions with no fraternities, versus community colleges in urban areas. and they all have very different cultures and systems, and it seems like there's a lack of involvement, governance, and input from people other than lawyers on what the processes should be, and I wonder if any of you had perspectives on that.
I'm happy to jump in a little bit on this, which is, I think a lot of the media conversation has focused on the adjudication process, the individual complaints. I think what goes on college campuses and higher education institution campuses is much broader, actually, from what happens at orientation to what happens during the semester and even what happens before arrival. And actually, OCR and the White House have had something to say about that in terms of encouraging schools to do climate surveys, requiring information provision during orientation. New York State there's now a student bill of rights related to some of this. I mean, to me, then the question is, well, what gets at the campus climate pieces? And there, I guess my observation, both at Columbia, where I've worked on some of these issues, and looking around at colleagues at really a wide range of other schools, is it's not lawyers. I mean, I happen to be a lawyer, but I don't think I'm doing that piece of my work in my legal capacity. It's not lawyers so much, it's student life professionals, right? And it's people who work in a sexual violence response or women's studies or entity on the campus. And I'll just mention what I do. So I'll just mention very briefly what we've done at Columbia to try to make a dent in the climate issue. And the climate, of course, is this is where there's certainly no barrier between society outside of an institution and within an institution, right? We live in a world of a lot of sexual violence, and of course that comes in, right? Of course it comes in terms of the experiences of the students. If you survey students coming first into college or a university setting, a high percentage of them will have experienced some sort of traumatic event or sexually violent event before they even get to school. So what sort of environment do we create for them? And what sort of supports do they need when they come right onto campus, as well as what happens in orientation, what happens beyond that. 30 seconds on one thing we've done at Columbia that's a little bit different than I've seen at other schools is we've created a requirement for students that is outside of orientation. It's called the Sexual Respect and Community Citizenship Initiative. It tries to create a positive frame around some of these issues, so sexual respect, links it to being a member of the university community, so the issue isn't an individual one, it's what kind of community to create together. There's all sorts of options that students can participate in. If you're curious and you Google Sexual Respect Initiative, and Columbia, you'll come up with some more information about it. Happy to share about that offline as well.
Wait.
Oh.
Did you want to answer that at all?
No, I'm good. I'm taking notes.
All right. I just wanted to jump in on one point in terms of Aaron's question. And the discussion that Rana was talking about in terms of looking at the issues broadly and looking at them in the context of what are universities doing with regard to programs about gender equality, about racial equality, about issues of class, that these are the kinds of ways in which we look deeply at issues rather than showing somebody a video. And I'm not saying that's what you're doing with some of these initiatives, but again, as opposed to simply training people and saying, okay, you've checked a box, you've done some training, our question is how do we integrate these very important issues of inequality and the ways that those inequalities express themselves on campus and off campus, because the campus is not just hanging out there by itself. But how do we look at that and as a university show a deep commitment to supporting inequality studies and actually addressing those issues in the ways that they can be very difficult to address, which is not to say we shouldn't have programs outside of the classroom. Clearly, there should be programs outside the classroom, but yet again, I think that faculty governance is part of that as opposed to giving it to an office of student life and saying, here, you do it. That's been part of the trend in universities is to separate off issues that are very certainly linked to academic life and calling it some other kind of life. So the more we integrate faculty into that process of figuring out how to do this well, the better off we are. And also to continually remind ourselves that we have to look at not just gender issues, but gender and race and class, the way they go together, the things we know about when we do these kinds of critical studies, and also immigration status and the kinds of issues that students deal with, to say how do these go together in ways that then enable us to address them deeply and well.
So one sentence to just add, which is that I agree that faculty need to participate in this. I also think students do.
Absolutely.
Right? So that program that I just mentioned, the Sexual Respect and Community Citizenship Initiative, actually came out of a working group of students, faculty, and administrators. What I'll also say, though, is that most people who are students and people who are faculty rarely have time to really motor something along and do the tremendous amount of logistical work it creates to sustain a program, to create the websites, to do the monitoring of compliance and all of this sort of thing. So that to do something like this without a close collaboration with administrators, I think it is a very hard thing to accomplish.
Sure, yeah. I mean, faculty and students should be allies in this. Right, and that's how we see it, and that's how we describe it in the report.
Go ahead, I'm sorry.
Hi, no, that's okay. Mary Ann Mahoney from Central Connecticut State University. I guess I want to take the conversation a little bit further. We've been talking about faculty reporting on problems that basically undergraduates bring to them. But how do we protect a faculty member from retaliation who reports on sexual harassment of students or others by a colleague within their department who may be a full professor when either the reporter is part-time or a tenure-track faculty member? And, right, because there are myriad ways that a tenure-track or that a tenure application can go awry, and how does one demonstrate, in fact, that it's retaliation? So there's sort of my question number one, and this, you can tell from, if you were at the previous discussion, we've got some issues in Connecticut. So the second thing would be, how do we protect faculty members who have perhaps done something unwise, but certainly not illegal, who get essentially hounded out of their jobs because the university is afraid of the press? And third, we now have students coming forward with grade complaints in the guise of race and sexual discrimination cases that are being accepted by the Office of Diversity and Equity, and they're going around the grade policy, the grade appeal policy. So these are questions about grades that never go through the standard policy. So I know I've just given you a lot to talk about, but, and if you don't want to talk about it all, we can talk about it later separately, but there may be issues coming up elsewhere. Thanks.
You want to go first? I just feel like I was talking too much. Do you want to go first?
I'll say something about the last question, the grade complaints in the guise of race and sex discrimination. I think sometimes this is one of those places where I think sometimes you might just have to accept that this might happen. I don't know. I've heard about this occasionally. I have no idea how frequent this is, and I'd really want to see something a little more empirical or have some very specifically documented instances of this before kind of intervening on this in a huge way or making recommendations that were really large on this. I think this question about untenured professors reporting on tenured professors and how to deal with retaliation. I'm really interested to see what you guys say about that. I'm untenured, so.
Yeah. Do you want to go first?
Sure. So I think these are three excellent questions and raise very, very serious issues. They're hard questions. I want to expand the first question, which is to say that I think untenured or faculty members who are less secure in their job status in general are wise to fear not maybe retaliation in a legal sense, but be concerned about reporting. I think the same is true for graduate students, right? This is one of the main reasons why so few graduate students report sexual harassment, even though I think there is fair empirical data, certainly from the AAU survey, that there's plenty of sexual harassment of graduate students by senior colleagues or faculty members or by senior graduates. So there's a lot that goes on that nobody reports. And so then the question, and this is not a question that's limited to higher ed settings, right? There's always the question about how to manage, how to enable meaningful enforcement of anti-discrimination protections in a workplace and how to protect against retaliation. And there are some basic things that institutions can do, right? Have clearly articulated protections against retaliation, have a clear means for somebody to file a complaint if they've been retaliated against. I don't think that that is going to get most people to actually file complaints because it's scary to do that, and it's scary to file a complaint against a colleague, which says to me then that in addition to those pieces, having serious enforcement and communication and effective communication, that they're also, institutions also benefit from having other channels to address these issues that may not involve a formal adjudication process, that may involve faculty briefing sessions, meetings, interactive sessions where these kinds of behaviors are where there's training. I don't mean training in the bad sense, I actually mean training in the interesting sense, where people talk about issues, say, of sexual harassment, so that more faculty become aware of or gain facility with the language around sexual harassment. And then it can sometimes turn out that senior faculty are also comfortable going and talking about it to sources. I mean, that's something I've seen. I think that works. In terms of the unwise but not illegal conduct and people being either threatened with or actually losing their jobs, I also think this is a reality of not just some higher ed institutions, but lots of workplaces. Something's controversial. If you're in an at-will employment situation, it's easy for an institution to say we're risk averse. Again, I think this is an area where briefing, training, conversation, whatever you want to call it, that is but useful, but that's interesting or fun or something that engages people is probably the best way to go. In terms of grade complaints coming in as other types of complaints, I also think that's that's a familiar story, right? Lots of times complaints come in under the guise of something else. I agree with Rana that sometimes there's a real race or gender or sexual orientation or class or whatever, any sort of aspect of identity that there can be something genuine there about in connection with a grade complaint. I also think sometimes these are ways to come in and access the system. And again, I just tend to think, and this maybe comes from my background as a law reform lawyer before going into academia, that creating multiple channels for conversation and education is ultimately the way to go. And my experience now knowing a lot of student life professionals is that at least the ones I know are very, very effective in talking with students and helping the students when sometimes come to see that what they are framing as a complaint or as an injury to them may actually be something else. And so again, being a little bit less formalistic about it and finding more touchstones for the conversation can be very useful.
Yeah. Let me just add a couple things. I think there are a lot of areas of agreement. Good policy and good process that implements the policy is necessary, perhaps not sufficient, but it's certainly necessary to protect faculty from retaliation of perhaps any kind that we find inappropriate. Retaliation tends to be a negative thing, but at least consequences that come from responses that we think are inappropriate responses. So if we have good policy, if we put together good policy, if we have faculty involved through governance and putting together good policy, and if faculty are involved in implementing the due process at a high enough standard so that we can be assured that we are putting into place the best approach possible to figure out what happened and to know what the standards are that we want people to be held to, and we know how much proof we need, that's a really good start. And this goes beyond the question of retaliation for reporting somebody on a harassment claim or sexual misconduct. There are issues in the tenure process, for example, on tenure reviews, that have to do with I've disagreed with a more senior colleague, or my approach to this subject is very different. And so we all know that those are realities as well. And again, I think good process can be very helpful. So a more open tenure process can be helpful to say, let's shine light on issues rather than keep them secret. So the more we have openness in those kinds of processes of promotion reviews, work evaluations, performance evaluations, I think the better we are at smoking out perhaps retaliation that might exist as opposed to rational disagreement with somebody's work. And as a cultural matter, the more we have protections of academic freedom as encouraging us to have difficult conversations that may upset people, that may hurt their feelings, that may be controversial, the more we may see that in other areas where faculty in dealing with each other are more willing to be honest about saying what you did was wrong and, let's deal with it. And then one other point about the unwise but not illegal. In the report, we have a discussion about restorative justice processes, alternative kinds of dispute resolution processes that don't go to the most formal kind of process, but says, are there other avenues where we actually can promote understanding, education, change in behavior in ways that, again, move us forward towards a goal of gender equality and gender equity, as well as racial equity and other areas that we're concerned about in terms of class relations, et cetera. Can we develop those so that we have those alternative ways to discuss the issues and actually improve things?
Okay, we have time for another question if anybody has one. Don't be shy. If not, we can cut this off 5 minutes early. But
No, don't do that.
don't do that, all right?
I have
been a
something else I
long
want to
day.
say.
We
have
talked
time.
fast, it's okay.
Ask us if we have anything else we'd like to add.
What do you want to add?
Okay, please.
Okay, oh, thank you.
No, if you'd like to say anything else?
Such a surprise, yes, okay. I do actually, and it's something that I think is a very serious issue that Suzanne raised, and since we do have a few minutes, I just wanted to go back to it, and that is that issue of the standard of proof. Does it matter if we have clear and convincing evidence as a stronger standard of proof in hearings about allegations of misconduct? And again, that may be sexual harassment, but it also might be other kinds of misconduct where faculty are facing discipline or dismissal of some kind. And I wanted to point out now, just looking at the issues of sexual misconduct or allegations of other kinds of sexual harassment, that the answer that, well, the civil system uses a preponderance of the evidence standard in non-criminal cases is a good enough reason for the universities to be required to use them or to choose to use the preponderance of the evidence standard. And I wanted to just address that with a few quick points that goes to why clear and convincing evidence is, in my view, and the AAUP's view, the better standard. One is the OCR is removing choices from universities to say, we think a higher standard of proof is an appropriate one given the risks that people face when they're charged with something like sexual misconduct and other kinds of sexual harassment. Another reason for universities to be able to make that choice, besides the issue of their reputation and their future, is we have academic freedom at stake in some of these cases. And so because of the weight of that interest, the additional proof may well be warranted, and OCR shouldn't cut that off as an option. Some of the conduct that may be charged may be criminal. And so at the very least, a clear and convincing evidence standard would be appropriate, if not reasonable doubt, beyond a reasonable doubt. And then I wanted to bring in one other thing, which comes from my work as a labor and employment law person, which is in arbitration under collective bargaining agreements, there are cases in which an arbitrator, it's a private dispute resolution process, in a dismissal case may use a higher standard of proof, like clear and convincing evidence, and even some arbitrators might use beyond a reasonable doubt because they use the term sometimes, or the phrase that dismissal is the industrial form of capital punishment. And so the kind of extreme and serious outcome may well warrant universities through, again, governance processes to decide it's appropriate to use a higher standard of proof so we can be more sure we're doing due process.
Anything else?
Yeah.
I naturally have thoughts in response, but I think I actually, you can never get a law professor off of the mic, but I think I really shared them before. I think my main point was really just to think about, was to encourage thought about the array of arguments both for and against. I think it's complicated. I don't think there is one clear right answer. And I do think that it may be that in some communities, one standard is more appropriate than another. I think there are communities that have a tradition of using a clear and convincing evidence standard for other matters. I think there are probably few that use a criminal standard, a beyond a reasonable doubt standard in employment matters, but maybe there are, and I'm just not aware of them. But one thing I do think is pretty clear to me is that when somebody brings a civil suit against, say, a faculty member for $1 million or more for, in connection, let's just say, with sexual harassment, and in that can be at least, if not more damaging than the campus-based adjudication and investigation and adjudication process, which is often not fully in the public eye. If I choose to file a complaint against a colleague for sexual harassment, I file a complaint, I can go on for 30 pages or more, if I choose, in excruciating detail of everything that I contend this colleague did to me. In campus process, and that's public, right? In the domain, I can post it on Facebook or do whatever I want with it. The media can cover it. In campus processes, there's often, even if not an actual practice in a public institution, a norm around some sort of discretion about how these incidents are publicized. And so I think there are just a lot of pieces in the mix to think about when we say, well, a civil standard is not necessarily appropriate in a university setting. It may be, it may not be, but I think there are complicated, multifaceted considerations.
On that note, I'd like to thank my panelists for being here today. I'd like to thank our audience as well. 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 Audience as well.
This ends a podcast from the 43rd Annual Conference of the National Center for the Study of Collective Bargaining in Higher Education and the Professions at Hunter College in New York City.